responsibility by reversing the impeachment of Governors Joshua Darie and Peter Obi, and severely restricting the powers of the President when a state of emergency is lawfully declared in any state of the Federation. All eyes are now on the Judiciary Court on the action of the current President to remove elected executives and legislators due to the declaration of a state of emergency. Many informed Nigerians are also curious to know whether 2/3 of all the members of the National Assembly, as required by the Constitution, can be decided without a division and physical count, but through voice votes, as the Akpabio and Abbas-led chambers did with such arrogant disregard for common sense. When people think of economic reform, ladies and gentlemen, they often think of economists and technocrats. But lawyers are indispensable in making reform legally durable and socially legitimate. Let me give 3 examples. As Minister of the Federal Capital Territory in 2003 to 2007, I discovered that the FCT was not being administered as required under its enabling legislation. The FCT is not a federating unit. It is not a state either. Rather, it is a territory established by the Constitution under the Federal Capital Territory Act, which is quite explicit and crystal clear about how it is to be lawfully administered. The FCT's administrative and development needs are placed by that act in the hands of the Federal Capital Development Authority. But before my tenure, over the years, the bureaucrats of the federal government had set up a ministry of the Federal Capital Territory to mirror the functions of the FCDA, supervise it as a parastatal, and often override it. We took a comprehensive review of the FCT Act undertaken by lawyers and an executive order comprehensively drafted by lawyers like Epo and Jimilawa and signed by President Olusegun Obasanjo to sweep away the ministry overnight, create the Federal Capital Territory Administration, FCTA, and restore the FCDA to its rightful position. The executive order also created 5 slim, functional secretariats headed by secretaries appointed by the President as equivalent of state commissioners. It was only after receiving a proper legal warrant from Mr. President under the FCT Act that my team and I were able to undertake the decent work we were able to do in the FCT back then. However, the powerful role that the law can play in shaping political and administrative reforms is exemplified in the way in which the FCT Act was deployed to create an appropriate structure to soundly manage the FCT and its agencies. We must insist on fidelity to the Act and the subsisting executive order of 2004 to ensure that it is not turned into an inefficient and sprawling bureaucracy. Before my stint as Minister of the FCT, I've had the privilege of being the Director General of the Bureau of Public Enterprises. The BPE back then was the engine room of some of the major economic reforms implemented by the administration of President Olusegun Obasanjo. But 3 are worthy of mention: the reform of the telecommunications, pensions, and electricity sectors of the economy. 2 of these, that is telecoms and pensions, were duly implemented between 1999 and 2003 while I was there with outstanding success. The jury is still out on the 3rd in the electricity supply industry, but I can say that none of them would have been attempted without the instrumentality of a raft of carefully considered new policies and laws prepared by a multidisciplinary teams of social scientists, finance experts, and of course, lawyers. Implementation too would have been impossible without them. I recall with satisfaction the roles played by Abdulkarim Adeshokan, a thoughtful economist and administrator who initially led the power sector team, Epo, a lawyer we brought in from the private sector, and the then Honorable Idris Umar, who later became a senator and minister, who was the chair of the House of Representatives Committee on Electric Power. These brilliant public servants worked very closely with Cameron McKenna, a law firm in the US, Anderson, and several Nigerian law firms to draft what became the Electric Power Sector Reform Act. Staying a little longer on electricity, the one sector in which we as a country are still very much challenged, We may observe that the latest reforms in the sector under the Electricity Act 2023 were preceded by the amendment of the paragraph 14B part 2 second schedule to the 1999 Constitution via the astute removal of a single word from that paragraph, which gave it the more expansive and federalist-oriented interpretation it now has. Once it was clear